In the month of July, when
Matter number 5, third Mr. S.
NZ as well.
NZ Ahmed, NZ Das, learned counsel for the petitioner, also Mr.
Bush.
K. Bush, learned additional public prosecutor, who submits that case diary of this case has not arrived. When praised for some time for producing the same, the prayer is allowed. Let this matter be listed after. No,
After
give
vacation.
it.
After vacation.
Yeah, you have to give a date, fixed date.
Yes.
15 lots.
15 July.
15.
Obliged.
Interim was there.
Fine.
Interim shall continue till next day.
I am obliged.
Please, Your Lordship. 439 application, Lordship. The petitioner is behind the bar since 2 years, 5 months, 19 days now. The LCR may be called for, Lordship. It is in Kamrup Metro.
Heard Miss N. Sultana, learned counsel for the petitioner. Also heard Miss M. Deka, learned counsel appearing for NCB. Perusal of the scan copy of the case record of NDPS case number 48/2020 would be required for consideration of the instant bail application. Hence, call for the same registry to issue requisition for the scan copy of the aforesaid case record. The trial court may also be requested to give. No, not necessary. Scan copy of the case record. Let this matter be listed on 17th of July.
Last time I did it.
27 June.
Applies, Lordship.
May it please your lordship, my lord. Your lordship was kind enough to release me on interim bail. I was arrested with 439 application. Your lordship called for the case diary. Because
In 439, you were given interim.
yes, my lord, your lordship was pleased because of the nature of the
Case
allegations.
diary is there.
Yes, CD receipt, lordship.
Now, was there any condition?
Conditions, my lord, was nothing as such. Lordship
No,
just-
in interim bail, where is the interim bail order? Where is the interim bail order page?
No,
This is.
this interim order given by this court, my lord.
Okay.
Lordship granted the bail.
Which date? 5/4.
Fine.
So whether, yes, Mr. Bush, whether he cooperated in the investigation
Well, I was never called up by the policeman.
or whether you require his custodial interrogation.
Also, here only what I have found, there's some 164 statement. There only the part is that some force was used by him. Otherwise, no such allegation. Only that part, because admittedly they have
Who is the
taken.
petitioner? Only mother is the petitioner.
No. Here it is the petitioner is the accused himself, my lord. It was affidavit was signed by his wife, Mukuta Begum.
No, what is the progress made in the investigation?
Progress, lordship, it is.
Whether you have, IO has recorded the statement of witnesses.
Yes, IO.
Is there any endorsement that custodial detention of the accused is necessary? Or is,
Lordship, here, after the registration of this FIR, lordship, that is on 28/3/2024. Another Azahar is found here on 29/3/2024.
filed by?
Filed by lordship, this Jivaneshwar Talukdar, Doli Talukdar. They are actually the victim. So, and from the 164 statement, it is found that they have taken an amount from loan, but after taking that loan, there the force was used and both the persons, one is, they are not medically fit persons. And they have taken from by using force, they have taken from the house, some signatures was taken. So that part is lordship there. And they have taken the signature and used to threaten them.
When you were, for how many days you were behind the bars?
My lord, I was arrested on 29 March. And then by the interim order, he was released.
When you were released?
My lord, very next day, the lordship passed the order.
6th April. So you were behind the bars for at least 7 days.
My lord.
So whether his custodial detention is necessary?
Lordship, only the parties that the victim statements and some parties.
No, you have to be
Oh.
specific. If you want him, you tell that I want his, or you may seek instructions. Otherwise, the interim would be made absolute.
May I submit? My lord? My lord, the whole allegation is that they have admitted in their FIR, they took money from me. And in lieu of the money, they failed to return the money. They have stated in their FIR that they have took money. If lordship can come to the FIR. Then my lord, FIR is at page 10 million. I would like to refresh the, my lord, whole thing, my lord, if lordship wants, my lord. And then, my lord, both the party, all the parties have applied for sale permission of a plot of land. Lordship knows, my lord, nowadays, my lord, sale permission cannot be granted by a normal application. All the seller and purchaser has to go to the plot of land along with the mandal from the circle office. Then photographs is being, it has to be clicked, giving the geolocations. Then on that photographs with affidavit, application has to be made to the Deputy Commissioner's office for granting permission, for land sale permission. And your lordship will see at page 16 that land sale permission was granted on 22nd February.
Just a minute. This bail objection by the investigating officer, this bail objection letter is dated 26/4. That is, it is not.
No, not before this court, lordship, I think. Because it is 29 for, it is maybe they have appeared before lower court, lords.
Okay.
Lower court rejected, my lord. We have, I have annexed the lower court's order and additional affidavit. The FIR was registered under sections, my lord, 420, 387, 506, read with 7C2 of Assam Money Lenders Act. 72C is a bailable offense. My lord, they took money from me, they failed to return, they executed applications for granting sale permission. Some of the co-parties signed even the agreement, sale deed, and some going back from the office of the circle registrars filed the FIR. And they said this is 420. I have committed forgery, my lord. But kindly say there must be some plausibility of the FIR must inspire confidence of this honorable court.
For all the offenses, maximum punishment is 7 years.
Below up to 7 years.
Up to 7 years. So
And lordship was pleased to grant the interim because 41A notice
41A
was
was
not given.
Okay. Yes, Mr. Bushoi.
Lord, 41A notice I didn't find. That notice.
Putul, Putul. You make your submission. Whether
That regarding 41A notice, that is, I didn't find in the city.
41A notice is
41A
not there.
notice, I didn't.
Now, do you want there?
Notice.
How many witnesses have been examined?
What's it here?
After your bail, whether IO has
No,
approached you?
I have never called. I have never been called. Even today morning, I got the information, instruction. Because I believe the case diary was here. That is why maybe it was not called.
Heard Mr. A. Chamor, learned counsel for the petitioner, also heard Mr. K. Bosho, learned additional public prosecutor. On perusal of the case record, it appears that the petitioner was allowed to go on interim bail. The petitioner was arrested on 29/3/2024 in connection with bail PS case number 45/2024. And thereafter, by order dated 5/4/2024, he was allowed to go on interim bail by this court on the ground that the mandate of issuing notice under Section 41A of the Code of Criminal Procedure, 1973, has not been followed in this case. Learned counsel for the petitioner has submitted that on the very next date of grant of interim bail by this court, the petitioner has been released on bail by the Court of Learned Chief Judicial Magistrate Nalbari in pursuant to the directions of this court. And since then, the investigating officer has never approached him for questioning with regard to which case?
Belcher PS case.
Belser PS case number 45/2024. Learned counsel for the petitioner has submitted that the petitioner has not violated any of the condition on which he was granted interim bail, and he is ready and willing to cooperate in the investigation of Belser PS case number 45/2024. On the other hand, learned additional public prosecutor has produced the case diary of Belser PS case number 45/2024 for perusal of this court. On perusal of the case diary, it appears that the investigating officer has examined some of the witnesses,
7 numbers.
7 numbers of the witnesses, and recorded their statement under section 161 of the Code of Criminal Procedure, 1973. Stop. Further, on perusal of the case diary, it appears that no attempt has been made by the investigating officer, whether his statement has been recorded.
No, Lordship, it is not up to date, Lordship, this CD is.
That though his statement has not yet been recorded,
I was not called.
though
Maybe recorded, I don't know, because he was,
in custody also.
he was in
His
custody
statement,
for at least 24 hours.
Is not there.
his statement is not there.
Learned counsel, learned additional public prosecutor also submits that the statement of though the petitioner was in custody for more than a week, however, his statement
Not-
under section 161 CRPC has not yet been recorded. Considering all the facts and circumstances, all the attending facts and circumstances of this case, as well as considering materials in the case diary, and the fact that the petitioner has not violated any of the condition imposed on him while he was granted interim bail by this court, the above named petition, the interim bail granted to the above named petitioner by order dated 5/4/2024 is hereby made absolute with condition number 2 and with condition number 1 and 2 attached to the said order remaining intact. Let a copy of this order be sent to the investigating officer of
Belcher PS.
Belser PS case number 45/2024. With above observation, this bail application is disposed of.
I'm obliged, deeply obliged.
Lordship, you were right, that is sent to the High Court on 26/4. They have sent the city on 26/4 itself. With that objection, that was before this court only.
When the
Yes,
case was
yes,
initially taken up.
Initially, but because it is 26/4 is only their date and it is forwarded to the public.
Okay, we have communicated the order, let him
Madam,
cooperate.
I'm obliged.
Four 39 application lordship, petitioner was,
Lordship, in this matter, Lordship, I need some time to go through this LCR. No LCR is received, Lordship. I didn't complete it. Able to complete this.
Let him go through.
I'm only on lordship, their period of detention lordship.
How many days?
1 year, 7 months, 7 days. lordship.
Let him go through.
And Caesar witness did not support my case.
When do you,
So any date, Lordship.
let it be on. Is it okay day after tomorrow?
Okay,
But we are, let it be on next week, Monday or Tuesday next.
yes, yes.
Monday is holiday. lordship. Tuesday, lordship, 18th.
Okay. Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. K. Bashir, learned additional public prosecutor, who submits that though the scanned copy of the case record of the trial court has been received, however, he has not gone through the same and prays for some more time for going through the same before he makes his submission. The counsel for the petitioner does not oppose the said prayer. Considering the submissions made by learned additional public prosecutor, the prayer is allowed. Let this matter be listed again on 18th of June 2024.
Okay. This matter, Lordship, Sarsit submitted.
My lord, petitioner has been.
You were on interim.
Interim bail, my lord. Interim bail order granted on 29/5/2023, my lord, 1 year back. And after interim, we appeared before the investigating officer.
Heard Mr. A. R. Sigdar, learned counsel for the petitioner. Also heard Mr. K. Bashir, learned additional public prosecutor, who submits that though the case diary was called for in this case, however, in the meanwhile, charge sheet has been laid bearing charge sheet number
CS number 60/2024, dated 30/4/2024.
when you were granted interim bail.
My lord, 29/5/2023, my lord.
Learned counsel for the petitioner has submitted that by order dated 29/5/2023, the petitioner, namely Abul Fazal Ahid, was granted interim bail by this court with certain conditions, and in pursuant to directions of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. Stop. In view of submissions made by learned counsel for the petitioner, and in view of the fact of laying of the charge sheet in this case, as the petitioner has cooperated in the investigation, the interim bail granted to him by order dated 29/5/2023 by this court is hereby made absolute with condition number 2 and 3 attached to the said order remaining intact. With above observation, this anticipative bail application is disposed of.
Deeply obliged, Lordship.
Item 6.
May I please, your Lordship? Lordship, 438 application, my lord. But it's a suspected case. The petitioner has been shown as absconder, my lord. And the FIR is at page number 14, my lord, where it clearly states that FIR against one Nazirul Islam, who himself pretended as a doctor, my lord.
Where is the FIR?
Page number 14, my lord.
Okay. Nazirul,
Nazirul is the main accused, my lord. And I am Mizanur.
how you are connected?
This the case has been charged already, and I have been shown as absconder.
Okay.
And during the investigation period,
Charge-sheeted under what provision?
under section, a lot of section there in my.
120
But
B,
the-
Charge sheet is laid under what provision?
Lordship, under section 120 B, 419, 420, 465, 468, 471, 326, 270, 313, 304, 511.
What is the maximum punishment
Life is there, my lord.
for which offense?
471 was is there, and 304 is also there.
Yes, Mr. Busha.
Lordship. So here,
You have any submission?
My lord. I have preferred and bail application before the learned court below, my lord. That is Assistant Session Judge Mori, my lord. The learned court below has rejected my bail pair, stating that there is page number 35, my lord. Lordship has gone through. Page 35. Second paragraph. Having heard, may I read, my lord?
Yes.
Having heard both the sides and having perused the case record and the case diary, it is seen that several accused persons were arrested in this case for the alleged offense of conducting illegal abortion by unqualified doctor. The allegations against the accused persons are of very serious nature, and hence I am of the considered view that PS bail cannot be granted to the accused petitioner. Here, my lord, the learned court below has observed that the allegations are very serious. That much. Whether my involvement is there or not, nothing.
No
has been
involvement
reported.
must be there, therefore
Yes.
charge sheet has been laid.
In the charge sheet, my lord,
Prima facie something, what is there against you in the charge sheet?
during the investigation period, neither I have been called for.
Okay, what is the allegation against you? You are not the doctor.
I'm nobody, my lord. I am nowhere connected in this
Then
case.
there must be some allegation in the charge sheet.
Lordship, in
What
the,
has been accused of? What is the accusation against you?
Lordship, in the
I
charge
think
sheet.
I think
No,
nothing has been stated in the FIR, my lord, against me.
In
The
the
police
charge sheet?
Police has never called me before the police station. Neither
No,
visited the
that I
house.
have understood. In the charge sheet also, there is no.
Yes, my lord. I'm going for that, my lord. Page number 29, my lord.
Yes.
Para 12. Several attempts have been made to arrest the accused Jinnatul Ali and Mizanur Rahman, but they are absconding till today.
No,
And
before that,
nothing
there
has
is no
been-
statement that
No.
what you have done.
No, my lord, nothing. The prosecution may tell much better than me, my lord.
Yes,
No,
Lordship.
What is the allegation?
Lordship, page number 28, Lordship, of the petition,
Wait,
Lordship. It is the
28.
third sheet, yes. Lordship, it is the para 5, Lordship, during the course of investigation. Recovered the victim Masuma Begum, whose abortion was illegally performed by accused Jinnatul Ali and Mizanur Rahman. Here now the Mizanur Rahman is the petitioner.
That is the allegation.
By making a fake nursing home at the building of accused Moinul Haq. Now, it is where it is made, the nursing home was in the place of Moinul Haq. Later, accused Moinul Haq took to 20,000 as abortion and Babul Ali was taken. Now, Lordship, in the CD also, now, as my learned friend has stated, it is the one, is a person who pretended as a doctor and as a gang of people who are running a hospital in the name of, in two different names. One is, here it is, related name is where the accused is coming, it is your this Zomiron Medical Hall and Nursing Room. Zomiron Medical Hall and Nursing Room. And Zomiron Medical Hall and Nursing Room, where this Nazrul Islam is that particular person was the doctor, and that was run in the Mainul Haq. And from the statement of both the co-accused, it is very clear that he is the other person who is who has that nursing room investor, and they are opening, and that part is in the city also, Lordship. And even Lordship, here the matter is that is the on 4/3/2024. That is the summon was issued, Lordship, as because they was declared as a absconder by police whenever the search sheet was submitted. And summon was issued, and on 13/3/2024, again that summon was issued. 27/3/2024, present petitioner was Mizanur Rahman was absent with state. And 28/5/2024, as per the order of this Honorable High Court, that copy was sent. That is, Lordship, after 27, it is in the stage of the motion stage when, Lordship, in the summon stage, when the summon was issued.
Then you appear before that court and pray for bail before that court.
My lord, that may be possible, my lord, and that is fixed on 15/7/2024. Till that, my lord, if I may be protected, my lord.
But till that, there is no apprehension because only summons have been issued.
That-
Till then, nobody will arrest you.
A direction may be given to appear before the learned court below, my lord, that may be okay.
No,
And if you see, my lord, page number 22, the learned additional people has said that I am doing some medical activities in there. Like in my in the search sheet, page number 22, my occupation has been reflected as nil by the IO. If I am involved in this offense, how my occupation can be nil?
Lordship, may
And
kindly.
in the FI itself,
no. Now the question is, as the court has issued summons to you,
yes, my lord.
why are you apprehending?
My lord, the case is triable by learned session court, my lord. The case is pending in additional CGM. I have appeared before the IO, sorry, my lord, learned court of additional CGM, but court is inclined to grant bail, my lord.
Lordship, may kindly peruse the LCR part, where the relevant part I have a flag mark, Lordship.
That apprehension may be genuine apprehension
My lord.
because of the 471 and that
Beautiful.
now
But Lordship, in this regard, then Lordship, we have to go by merit of the case. In that case, if my learned friend
whether
make this
detention is
submission
necessary
on
or
that, on 438 application, make this submission at this stage, Lordship, when someone who is issued, then Lordship is
no,
on.
someone has been issued. But even if he appears before the Court of Learned Additional CGM, because of that embargo of 437(1), that where the punishment is life imprisonment or death penalty, unless he is innocent, but still you can pray.
That's why I appeared before the session court, my lord.